Anthony Julie on behalf of the people.
Noah Marishai from Ms. Anick, who appears in person in custody to my right.
All right, good morning. We're here for sentencing on the High Court misdemeanor of lying to a peace officer with the advisory guidelines scored at 0 to 11 months. Mr. Nightingale, any additions, corrections, or modifications to that report?
Not to the guidelines themselves. I would just note that on CFJ 145, page 1, it does state that her district court case has a 2-year max. When I go back and I look at that judgment of sentence, that judgment was not marked consecutive. So I would interpret that as a 1-year max, but would leave that to the court's discretion on whether to update that or not.
Oh, well, it's a probation max. So I read that as just the length of her probation term. Is she on a 2-year term of probation?
That is correct, yes.
All right, any additions, corrections, or scoring challenges from the people?
Just one correction, same page, currently under sentence. She's actually not under sentence right now in district court. She will be sentenced this Thursday.
Oh,
Friday, I believe.
Friday, excuse me.
oh, so she's, wait, what's the October 10th sentence? It says she's on probation.
I believe that's when she was sentenced to probation in district court, was on 10/10/25.
So then she's under sentence, under
Okay,
probationary
correct.
sentence. Is she being sentenced for a probation violation? That's right.
That is correct.
So she is under a probationary sentence, so that still is correct. Okay. Do council know what the anticipated sentence in the district court is? Is it a continuation or a discharge of probation?
I would anticipate a discharge.
Okay, thank you. Mr. Nightingale, anything you want to say on your client's behalf?
Yes, Your Honor, thank you. So Ms. Anick comes before the court today, 19 years of age. She has 2 prior felonies that we've just referenced out of district court, but those are, attempted to commit felonies. She did plead to misdemeanors down there. Understanding, obviously, that's going to be used against her in the future, but nonetheless, that is, I think, the extent of her adult criminal history is what's downstairs. She does have some juvenile record that I'm not gonna comment on too much, but she's a very young person, right? She comes before the court, as I said, at 19 years of age. She does have decent family support. Her mother's here today. Kathleen's in the back here to support Caitlin. As we've said just previously, I do think that she's going to be discharged from that probation down in district court. She was sentenced to essentially a sobriety court term of probation for 2 years. She was on probation for, I believe, about 2 weeks. And then this incident happened. She was sort of getting on the on-ramp, right? And then was sort of immediately derailed. And I think in her process of getting on that on-ramp, she had at least lined up some employment. She hadn't started that employment yet, but had lined it up. It's my understanding that she could go start work, tomorrow if she were to be released, but I'm not sure if the court's going to do that or not based on the recommendation for 6 months. She also was to get a substance use assessment set up, participate in those counseling services. I think everyone in the room acknowledges, 2 weeks is probably not enough time to have that stuff actually set up, let alone to be able to get that report back and then begin those services, which is just unfortunate. I think that Ms. Anick, as it's outlined in the PSI, and
Miss Anick, you're only 19, yet you've already exhausted the court's patience. Others gave you chances. You kept choosing crime. That stops today. I'm more interested in whether you can change than how many days you sit in jail. Probation is your opportunity. Don't waste it.
And so I hope that this process for her has been a really big wake-up call about who she does and does not associate with in the real world. She's got a long life to live, ideally. And, these choices could come back and haunt her, right? If she doesn't continue to make the right ones, or if she continues to make the wrong ones, either way. She does need to finish her schooling, it sounds like, and I think she's aware of that. Judge, in my communications with Ms. Anick, she's a person who is very blunt. I mean, that's just sort of matter of fact. I think the court may or may not get some sort of negative perception from her about the way that she carries herself. I think that some of that is youthful ignorance, maybe, about, you know, how others perceive her as she travels through the world. I think some of this is also a response to trauma, and I think some of that trauma is outlined in the PSI for her. That goes back when she was 3 years old. I think the court's aware of who her biological father is, and the kind of life that she was subjected to until she was thankfully, you know, I'll call it rescued by her grandmother and now her mother. And so I'm certainly thankful that Miss Lancourt stepped up and was able to take care of Miss Anick and her siblings. You know, it sounds like she just has still a positive relationship with a lot of her family members. Obviously, I continue to encourage her to seek that good family support and to shy away from these folks who are going to cause her to make poor decisions. As outlined in the PSI, you know, Miss Anick does give a statement that I think pretty much encapsulates this whole case, right? She's hanging out with the wrong people. She gets busted, and then she lies to try to save them, and in doing so, you know, really shoots herself in the foot, not just with this case, but with her sobriety court probation sentence. And so all that considered, I mean, the recommendation is pretty fair and measured. Her guidelines are 0 to 11 as outlined in the report. She does have credit for 116 days. This is the longest, to my knowledge, that she's been incarcerated. I think she served 50 days, 50 days on the probation sentence in district court before she was released to probation. And so what I think maybe if the court would consider giving her a 4-month window of initial incarceration, allowing her to start this probation period. I do not know what her sentence is going to be in district court. You know, she's subject to a year. And so, you know, if Judge Ekdahl's very mad at her, which he may be, that may be what she's doing. I'm not sure at this point. But as far as this case is concerned, we would like to get her probation started sooner rather than later. And that's what we're asking for today. Thank you, Judge.
Thank you, Mr. Nightingale. Ms. Anick, you don't have to say anything today, but you're allowed to. Is there anything you want to tell me or no?
Yeah.
Go ahead and stand up.
That night, I was trying to be nice. I was trying to help people, Pat. I had no idea that they were going to steal a car. I had known before. I should have known when they were talking. And I was like, I was trying to do the right thing and be a good friend to somebody who was not a good friend in return and got me in trouble. I should not have run, and I should not have fled that night. I did that because I was scared of what was going to happen. I went home and I turned myself in. I told my mom what happened, and I turned myself in. I lied to try to like deflect the blame from myself, and that was wrong. I admit my wrongs, and I'm sorry for my actions.
All right. Thank you, Ms. Anick. You can have a seat. Mr. Juliet, any recommendations from the people?
Yeah, and I would ask for a sentence at near the top end of the guidelines. I was the prosecutor in probate court when she was a juvenile, and she was under juvenile probation there for the longest time. Not long after that, she got the 2 attempted felonies at district court for which she was on probation, intensive probation. I mean, we had to basically draft our own probation sobriety court terms for her, and that only lasted 2 weeks until the instant offense. I recognize this is not the most serious high court misdemeanor. It's a 2-year max, but probation just doesn't seem to be working, and I recognize that she's only 19 years old, but it's just not working. If the court's not inclined to give a near the top end of the guideline sentence, I would ask for, at a minimum, a longer term of probation, because otherwise I suspect, and I'm just guessing here, she'll pick up another felony and be a habitual fourth at the age of 19 or 20 years old. Thank you.
All right. Thank you, Ms. Anick. If you please stand for the court sentence. Ms. Anick, this is your first time in front of me on a criminal matter. I know you've been in front of me on something else, but you're only 19 years old. And it sounds like, you know, you've been in enough trouble in the juvenile court and in the district court that, you know, the prosecutor's office is to the point where they're kind of throwing up their hands, and we've been trying with Miss Anick and she's not cooperated here. And that's completely understandable from their perspective, right? I mean, they've given you chances and you've just continued to commit crimes. Circuit court's, you know, a different deal. You know, when you're on felony probation, then, you know, there's a lot of time that can be over your head, even though this is a 2-year statutory maximum. You know, if you commit more crimes on felony probation, you'll end up doing a significant amount of time. It's concerning to see at only 19 years of age. In the pre-sentence report, the Compass assessment, you know, there's just a lot of services that are recommended. And your risk scores are medium and high. Sounds like you were only on probation with the district court for a very short period before this offense. And the sentencing offense is for lying to the police about the situation where you and some of your co-defendants were stealing a car, fleeing from the police. I know you're not the driver, you know, but you're with them, you're involved, you're lying about it. That's dangerous, troubling stuff. And, you know, that's going to quickly get you in a lot of trouble. I don't know what the district court's going to do. Maybe you'll do a year in the district court. I don't know. But I think I'm more concerned about what services we can try to provide for you on felony probation than exactly how many days you do on this charge on the upfront part. So what I'm going to do is I'm going to place you on probation, but it's going to be for not the 1 year as recommended, but I'm going to place you on probation for 2 years, for 24 months, subject to the terms and conditions listed on pages 2 and 3. I want to highlight a couple of those. You have to complete substance abuse treatment when referred. You're going to have to complete your education. You're going to have to get and keep a job. I am going to strike paragraph 12, the no contact provision with the co-defendants. I think that makes a lot of sense on as a bond condition under these circumstances. As a probation condition, I think that would be difficult to enforce. And the benefit for trying to enforce it would not outweigh that. There's a crime victims assessment of $130, court costs of $350. You have to comply with DNA testing and pay a $60 fee, $68 in state costs. There is a monthly supervision fee to the Department of Corrections. And I think for all the information listed in the pre-sentence report, I'm more interested in probation than incarceration in this case. I'm going to order that you serve 116 days jail and give you credit for 116 days previously served. So that means on my order, you'll be able to be released and begin your probation. But that's up to the district judge of how soon that's going to be. So then, you know, your attorney can present that on Thursday or Friday to that court. But within 24 hours of your release, I want you contacting your supervising agent, Agent Martin, so you can get going on probation. I imagine there's a hold in the district court, so she's going to be in custody till Friday then?
Yeah, there's no bond.
Okay. All right. You're eligible for early discharge from probation up to halfway point if you've succeeded on probation. We're going to hand you a piece of paper explaining that. Also, if you wanted to appeal, you can do so by filing an application to the Court of Appeals. If you wanted a lawyer, you'd have to ask within 6 months. So we're going to hand you a piece of paper about those appeal rights and ask you to initial one copy for us. The other ones to fill out if you want to take an appeal. Do you have any questions for me, Caitlin?
No.
Okay, good luck to you.
Thank you, Judge.
Let's go off the record for a second. All right, good morning. We're back on the record in the 53rd Circuit Court for the County of Sheboygan. As a reminder, we are providing public access not only in the courtroom, but also online. And up next, we have People v. Noah Marishai. It's 5 file numbers, 25-7100, 7101, 7102, 7103, and 7104. Counsel, you want to state your appearances, beginning with People?
Anthony Julian, on behalf of the people.
Mark Dobiash on behalf of defendant Noah Marishai, who's with me today.
All right, Mr. Marishai, would you please stand and raise your right hand as best you can for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Okay, you can have a seat. Are you Noah James Marishai?
Yes, Your Honor.
Mr. Marishai, I have a plea agreement in front of me. Is that how you want to proceed today?
Yes, Your Honor.
Now, a guilty plea hearing is an important event. I want you to listen carefully. If you have a question for me, ask it. I'm happy to answer your question. If you need more time with your attorney, you just let us know. We're happy to give you that time. Do you understand that?
Yes, Your Honor, I do.
Now, I have to advise you of the maximum penalty that you could face for each of the charges that you're pleading to. In 7100, you'll be pleading guilty to counts 2 and 4. Count 2 is fleeing and eluding from the police in the 3rd degree. It's a felony punishable by a maximum of 5 years and or $1,000, and the Secretary of State will suspend your license for a year. Count 4 is unlawful driving away a vehicle. It's a 5-year felony, Secretary of State to suspend your license. In file 7101, you're pleading guilty to count 2 and count 4. Count 2 is home invasion in the 2nd degree. That's a felony, punishable by a maximum of 15 years and or a $3,000 fine. Count 4, larceny over $1,000. It's a felony punishable by 5 years and or a $10,000 fine or 3 times the value. File 7102. You plead guilty to count 1. That is a financial transaction device, illegal sale or use. It's a felony punishable by 4 years and or $5,000 fine. Count 7103. You'll be pleading guilty to count 2, which is breaking and entering a building with intent. That's a felony punishable by up to 10 years in prison. In file 7104, you're pleading guilty to count 2, unlawful driving away a motor vehicle. It's a felony punishable by 5 years and your license will be suspended. Do you understand the maximum penalty you would face?
Yes, Your Honor, I do.
Are you on probation or parole?
Mr. Marishai, from this moment forward, any misconduct ends your deal. If you pull more of that behavior in jail, I can send you to prison and you won't withdraw your plea. Take this seriously. This is your warning. The next mistake won't come with leniency.
Yes.
Okay. So you're unaware of any consecutive sentencing requirements or discretion?
Correct.
Okay. All right, Mr. Marishai, if you plead guilty, you will not have a trial of any kind, and you'll give up the rights that you would have to a trial. Do you understand that?
Yes, Your Honor, I do.
I want to remind you of the more important of those rights. You'd have the right to be tried by a jury and at that trial to be presumed innocent unless and until the prosecutor proved your guilt beyond a reasonable doubt. You understand that?
Yes, Your Honor.
At that trial, you'd have the right to have the witnesses against you appear and you'd have the right to question them. You understand that?
Yes, Your Honor, I do.
At that trial, you'd have the right to present witnesses in your own defense and have me order those folks to show up. Do you understand that?
Yes, Your Honor.
And at that trial, you'd have the right either to testify in your own defense or to remain silent and not have your silence used against you in any way at all. Do you understand those rights?
Yes, Your Honor.
Do you have any questions for me or Mr. Dobiash about any of those rights?
No, Your Honor, I do not.
Do you wish to give up those rights and enter this guilty plea today?
Yes, Your Honor, I do.
If I accept that plea, you also give up any claim that the plea was caused by any threats to you or by any promises beyond what's put on the record today. Do you understand that?
Yes, Your Honor.
Also, when you plead guilty, you give up the right to appeal. And if you wanted to appeal later to a higher court, you have to seek permission to appeal, and they don't have to take your appeal. If they do take your appeal, the types of issues that you can raise are very limited, much more limited than if you were convicted after a trial. Do you understand that?
Yes, Your Honor.
The plea agreement provides in exchange for your guilty plea to the charges that I outlined, the prosecutor will dismiss the balance of the charges, Restitution will be in an amount to be determined later. And there's a sentence agreement for a county cap, meaning that at the sentencing, I could put you on probation, and if you violate probation, you could go to prison, but the initial sentence would not be prison, be local jail, no more than a year in the county jail. Do you understand that?
Yes, Your Honor, I do.
Mr. Dobiash said a full, fair, and accurate statement in the terms of the agreement.
It is, if I can add to that,
Yes.
I explained to Mr. Marishai, and we talked about it, the judge does not necessarily have to follow the prosecutor's recommendation. You understand that?
Yes, I do.
Okay.
All right, Mr. Juliet, is that full, fair, and accurate statement of the terms of the agreement?
It is.
So, Mr. Marishai, what your attorney's getting at is, I'm not part of this agreement for the county cap, so I don't have to follow it. I don't know much about you other than that you committed a whole string of crimes. At the sentencing, I'll know more about you. Some of that is through you and your attorney telling me what you want. Other is through a pre-sentence report where there's a investigation into your life and circumstances, so I can know what's going on with you. If I decide, gee, Mr. Marishai needs to go to prison, I don't have to follow this agreement. But if I don't follow this agreement, you would be given the opportunity to withdraw your plea if you want, because you wouldn't be getting what you bargained for. Do you understand that?
Yes, Your Honor, I do.
There is a very important exception to that rule. If you engage in any misconduct between now and then, between now and the sentencing, say violating court orders, misconducts in the jail, crimes in the jail, if by your own misconduct, then you would lose the right to withdraw the plea, even if I don't follow the agreement. Do you understand that?
Yes, Your Honor, I do.
I want to impress upon your mind for the following reason, and your attorney may not know about this. I just want to let you know, I was advised that you had some rules violations in the jail that would violate court orders about contact with a co-defendant. I'm not going to do anything about that today. I'm going to let that be a jail violation issue. But starting from the moment you enter this plea, you pull more of that crap, then guess what? I can send you to prison and you don't get to withdraw your plea. So you want to take very seriously following the rules back there. Do you understand that?
Yes, Your Honor, I do understand.
Other than the terms of the plea agreement, has anybody promised you anything to get you to plead guilty?
No, Your Honor.
Has anybody threatened you to make you plead guilty?
No, Your Honor.
Is doing so your own free choice?
Yes, Your Honor.
All right, so in file 7100. How do you wish to plead to the charge in count 2, fleeing, eluding in the 3rd degree?
Guilty.
How do you wish to plead to the charge of unlawful driving in a motor vehicle?
Guilty.
So back on October 19th of last year, were you in Sheboygan County?
Yes, Your Honor.
Did you, were you driving a 2017 Chevy Suburban?
Yes, Your Honor.
Did that Suburban belong to you?
No, Your Honor, I did not.
Did you take that with the owner's permission?
No, Your Honor.
And did you take that vehicle in Sheboygan County?
Yes, Your Honor.
Okay, and you knew you were driving somebody's car that didn't belong to you without permission?
Yes, Your Honor, I do.
And while you were driving that car, did you have some, did the police come in contact with you? Just a patrol vehicle?
Oh, yes, Your Honor.
Okay, and did you see that there was a marked patrol vehicle behind you?
Yes, Your Honor, I did.
Did they turn on their emergency lights to indicate they wanted you to stop?
Yes, Your Honor, I
So
did.
you knew that they were directing you to stop your vehicle?
Yes, Your Honor.
Did you stop that vehicle?
No, Your Honor.
And was the area where you failed to stop from to the police, was the speed limit 35 miles an hour or less? Do you remember where it was?
I believe so, Your Honor.
Okay. You satisfied with the factual basis in that file, Mr. W?
I am, Your Honor.
Mr. Juliet?
Yes.
Okay, Mr. Marishai, in file 7101, you be pleading guilty to counts 2 and 4. Count 2 is home invasion in the 2nd degree. How do you wish to plead to that charge?
Guilty, Your Honor.
How do you wish to plead to the charge of count 4, larceny over $1,000?
Guilty.
So this is back on July 16th of last year, 2025. Were you in Sheboygan County?
Yes, Your Honor, I was.
And did you enter a home on Town Line Road in Sheboygan County?
Yes, Your Honor.
Was that your home?
No, Your Honor.
Did you know whose home it was?
No, Your Honor.
Did you have permission to enter that home?
No, Your Honor.
Okay, and while you were inside the home, did you commit a larceny? Did you steal something?
Yes, Your Honor.
What is it that you stole?
Tools.
Okay, and those were power tools?
Yes, Your Honor. They
And
were.
those belong to somebody else?
Yes, Your Honor.
And based on the number of the tools that you took, do you agree that the value of those would have been somewhere north of $1,000?
Yes, Your Honor.
Mr. Dobias, you satisfied with that factual case?
I am, Your Honor.
Mr. Juliet?
I am as well.
Mr. Marishai, file 7102, you be pleading guilty in count, or how do you wish to plead in count 1 to illegal sale or use of a financial transaction device?
Guilty, Your Honor.
So back on October 14th of last year, were you again in Sheboygan County?
Yes, Your Honor.
And did you use a financial transaction device like a credit or debit card?
Yes, Your Honor.
What was it?
I had a cash app on my phone and I got a credit card in somebody's vehicle and put it on my cash app.
Okay, so you knew that credit card or debit card belonged to somebody else,
Yes, Your Honor, I did.
and you obtained and held and used that card without the owner's permission?
Yes, Your Honor.
And did that occur in Sheboygan County?
Yes, Your Honor, I did.
Mr. Dobias, you satisfied with that factual case?
I am, Your Honor.
Mr. Juliet?
Yes, sir.
And Mr. Marishai, in file 7103, how do you wish to plead the charge in count 2, breaking and entering a building with intent?
Guilty.
So, Mr. Marishai, back on May 17th of last year, were you in Sheboygan County on that date?
Yes, Your Honor. I was.
Did you enter into a building on State Street?
Yes, Your Honor.
And was that a dwelling as well?
Uh,
Was that somebody's home, do you know?
Yes, Your Honor.
Did you have permission to enter that?
No, Your-
Okay. And did you know that building belonged to somebody else?
not at the time. I did not.
You didn't think it was yours?
No, Your Honor. I knew it was not mine.
Okay. And when you went inside, did you have the intent to steal something inside that building?
No, Your Honor.
For what purpose were you going in the building?
Just to get out of the rain.
Okay, did you do anything while you were in the building?
Yes, Your Honor.
What did you do?
Stole a PlayStation.
Okay. All right. Mr. Dobias, that would establish the factual elements for the greater offense in count 2. Not as charged, but it would establish a home invasion in the second degree for committing a larceny while inside. So I'd accept that as a factual basis to the lesser breaking and entering, which does have the specific intent requirement, even though that intent was not established on the record, the completed larceny was. Do you concur,
I would agree.
Mr. Juliet?
I do as well.
Mr. Marishai, in file 7104, how do you wish to plead to the charge in count 2, unlawful driving away a motor vehicle?
Guilty, Your Honor.
So this, Mr. Marishai, is back on May 18th of 2025. Were you in Sheboygan County again?
Yes, Your Honor.
And did you drive a 2018 Chevy Equinox?
Yes, Your Honor.
Was that your car?
No, Your Honor, it was not.
Did you know that it belonged to somebody else?
Yes, Your Honor.
Did you have the permission of the owner to take it?
No, Your Honor.
So you knew you were driving away somebody's car without their permission,
Yes, Your Honor.
and that occurred in Sheboygan County?
Yes, Your Honor.
Mr. Dobias, you satisfied with the factual basis?
I am.
Mr. Juliet?
I am.
Mr. Dobias, you aware of any other promises, threats, or inducements for this plea?
There are none. The complete plea agreements contained in the agreement.
Mr. Juliet?
There are none.
And Mr. Dobias, in your judgment, has the court fully complied with the requirements of MCR 6.302 for plea taking?
It has, and then some.
Mr. Juliet?
Yes, it has.
All right, Mr. Marishai, I've asked you a lot of questions, given you a lot of information. We've gone through a lot of files. So I just want to confirm that this is what your choice. How do you wish to plead to all these charges you've articulated here today? Guilty or not guilty?
Guilty, Your Honor.
And are you pleading guilty because you are guilty?
Yes, Your Honor.
All right, Mr. Marishai, I find that your pleas are knowingly, voluntarily, and understandingly made, and that there is a sufficient basis in fact and law to believe that you're guilty of those offenses. So I hereby accept your plea. we could schedule sentencing, Mr. Tobias, for we could do the morning of March 10th, 4 weeks out. You available that date?
I,
Or we
I
could do the
could-
17th.
17th, I'm in trial in federal court, so,
Okay, well, let's try the 10th because then my
Yeah.
next date wouldn't be until late April.
yeah, we
So
can,
let's try March 10th at 10:40 in the morning. Would that work?
be here. I'll double check my schedule. I think I'm good on that date.
Okay. All right, Mr. Marishai, you'll have to cooperate with a pre-sentence report for an interview. Someone from the DOC will be back to talk with you in the jail to interview you. You have to cooperate with that. I guess what I'll tell you is, I told you, I don't know anything about you other than you committed all these crimes last spring, summer, fall. That's pretty bad, serious crimes. But I'll say initially, you've, the way that you've admitted what you've done today is a good step in the right direction. Sometimes when people even enter their plea, they're hesitant to be honest with me about what their involvement was. And that usually doesn't speak well for their success on any possible probation. So I'm hopeful that maybe you've kind of awakened to the fact that the way you were behaving is completely improper. So I'm just letting you know that's a promising sign today how you've behaved yourself with entering that plea. All right, anything further from the defense?
Yeah, just a question on the pre-sentence interview. I typically would like to be present. Is that part of it?
That is totally allowed, yep. So if you want to, before you leave, if you want to check in and make sure that the probation department knows that,
Okay,
that they should be reaching out to you so that they can coordinate that with you.
that'll work.
Okay, we'll see you in a month.
All right, we'll see you, Noah. Yep. Okay, see you guys later. Yes.
All right. All right, and our next case would be People v. Stephanie Becker. It's two files, 25-7067 and 7068. Counsel, you want to state your appearances, please?
Melissa Gooder, Spring County Prosecutor.
No, I guess we'll Becker who appears in person, eventually to my right.
Okay, and Ms. Becker had withdrawn her previously entered plea. Because I couldn't follow the sentence agreement legally, and now there's a new plea agreement. Is that how we want to proceed, counsel?
Yes, sir.
Yes, Your Honor, thank you.
Okay, Ms. Becker, you want to stand and raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Okay, you can have a seat. And Mr. Nightingale, do you consent to the filing of the amended information in 7067?
I do.
Ms. Becker, 7067, now it's been altered from the possession of methamphetamine to a use of methamphetamine, which is a lower offense. It's a misdemeanor punishable by a year and/or $2,000 fine. Do you understand that?
Yes, Your Honor.
Now, I guess let me ask, would counsel want me to ask Ms. Becker to reaffirm her previous plea taking and just have this reduction, or should we go through the whole
That was sort of my thought, is that we just incorporate whatever
Okay.
that prior admission.
No
Right.
objection.
So Ms. Becker, do you recall entering your plea previously to 2 counts of possession?
Yes, Your Honor.
Okay, you remember all the rights we went through?
Yes, sir.
Do you understand that by entering a plea, you don't have any of those rights? You give them up and you don't have a trial?
Yes, sir.
Do you reaffirm today all the statements you made when you entered that plea?
Yes, sir.
Ms. Becker, I recognize your medical struggles, but bond violations don't disappear because life is difficult. Probation is being granted, not because everything was excused, but because accountability and treatment matter more right now. You must comply fully. This is your structured second chance.
I do find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis, in fact, in law to believe you're guilty of those offenses. So I accept the plea. I mean, we'll need to just have them change the PSI a bit so that there's nothing on record that she's got the 2 felonies. Otherwise, I would think we could just maybe even go forward.
I was hoping maybe we could just do it today.
We could just do it today and then ask the department to alter the 7067 portions of the PSI.
That would be our request if the court is comfortable doing that.
Any objection to that, Ms. Goodrich?
No objection.
So with that being the only recommended change, did you have any other additions, corrections, or scoring challenges, Mr. Nightingale?
No, Your Honor.
Any from the people?
No, Your Honor, other than it looks like the Mackinac case is still pending. So,
Mr. Nightingale, anything you want to say in your client's behalf?
Yes, Your Honor, thank you. So Ms. Becker comes before the court, 42 years of age. I don't believe that she's had a birthday since this PSI was prepared. Judge, she's got a pretty limited record, 1 prior felony, 2 prior misdemeanors. These are her first, I think, serious run-ins with the court involving methamphetamine. Obviously, hopefully this is her last, as the court, I think, is really aware at this point. Ms. Becker's been struggling with some very serious health issues for months now at this point. She is still going through some cancer treatment. I have provided the court 1 document today regarding, it says that she had an insertion of a breast implant on the 12th. That's not correct. She had a brachytherapy on the 12th that actually lasted through the 14th, I believe. It was like a 3-day process for her where she couldn't do anything besides lay on her back and get stabbed with needles. And so I think that Ms. Becker, frankly, has been through a lot in this court process, more than most people, thankfully, have to do at once, ever. Most people, thankfully, are not ever charged with a felony. And, thankfully, most people are not diagnosed with very, very serious cancer in their 40s, their early 40s at that. And Ms. Becker has had to deal with both of these at the same time. Has she been perfect in that process? No, absolutely not. I think the court has been pretty frustrated at certain times with her performance on the bond line. If you ask Ms. Becker, she's doing her best. She's not been able to work since she's been diagnosed with cancer, and she's still supporting small children. Her husband, I think, is out of work right now. She's back living with her parents for the most part, relying on them for transportation, for funds, for everything. And thankfully, she has that good family support to rely on. I don't know where Ms. Becker would be right now if she didn't have her parents supporting her like that. I think we'd be having a much different conversation about Ms. Becker. But thankfully, she does have the good family support. I do think she's going to be a good candidate for probation when she's able to move past these health issues. And I think, frankly, once she has an assigned probation officer to her, that she'll be able to have that better communication with them, be able to get these documents over to them right away, and be able to come off this bond line, which has really been the bane of her existence besides cancer at this point. So, Judge, for all those reasons, we're going to ask the court to adopt the recommendations contained within the PSI. Sans, putting her on 2 7411s, putting her on the 17411 for the possession case, putting her on probation, or time serving her for the misdemeanor at this point. I don't know how the court wants to do that, but I think that Ms. Becker would be a good candidate for probation, and we would ask the court to affirm the recommendations contained therein. Thank you.
Thank you, Mr. Manager. Ms. Becker, you don't have to tell me anything today, but you're welcome to. Is there anything you want to say? Or
No, Your Honor.
okay, that's fine. Ms. Goodrich, any recommendations from the people?
Thank you, Your Honor. The defendant has 1 prior felony and 2 prior misdemeanors. This would be the first drug-related felony. These were true possession cases, not delivery cases. So we would ask the court to follow the plea agreement on the 7411 as to the felony charge and put Ms. Becker on probation to address those substance abuse issues. Thank you.
All right, thank you. Ms. Becker, if you please stand for the court sentence then. On the, I think I'll first impose sentence in time on 7068 so that we don't disqualify her for a 7411.
Thank you.
And in that file for, looks like that was a possession of, looks like even a residue possession case during a traffic stop. There hasn't been perfect compliance on bond, to be sure. I know there's been some health problems. It's still a bit murky in my mind to what extent they excuse some of the lapses on bond. My impression is that they don't entirely excuse the extent of the lapses on bond. But at this point, we're going to put her on probation, so I'm going to dismiss the pending contempt citations. And I'm going to, in 7068, place you on probation with the Department of Corrections for 18 months. Under section 7411 of the Public Health Code, which means it'll be a non-public file. If you successfully complete the terms of probation, the charge will be dismissed. On that term of probation, you have to comply with the terms and conditions listed on pages 3 through 5 in the pre-sentence report. Obviously, they include drug testing and treatment. They also include a crime victims assessment of $130, court costs of $350, state costs of $68, and a monthly supervision fee to the Department of Corrections. Because it's 7411 probation, we're not entering a judgment of sentence at this time. Therefore, we don't give you the appeal rights at this point because there's no judgment that's going to enter of your conviction. Okay. In 7068, that's now a use of methamphetamine. That was again a possession of methamphetamine during a traffic stop, pled down to the misdemeanor use. For that, I'll just assess the fines and costs of $50 for misdemeanor state cost, $75 for misdemeanor crime victims assessment, for a total of $125 in that file. Okay. So we are entering a judgment on that file in 7067. So we're going to hand you a copy of your appeal rights in that file. If you wanted to appeal, you'd have to ask me for a lawyer within 6 months. I speak to initial 1 copy for us, the other ones to fill out if you want to take an appeal. You can pay the $125 down at the clerk's office. And then I want you to stop in at the probation department before you leave today and tell them that you were re-entered your plea and were sentenced, and they can get you going on probation. Okay.
Thank you, Your Honor.
Okay. Any questions for me?
If I can't pay that fine today,
Then you set up a payment plan with my staff.
thank you, Your Honor.
Okay. Good luck to you.
Thank you, Judge. Yes, 676.
And that concludes our learning docket. We'll be in recess till 1.
Thank you.